यस सर, क्या हुआ रे, नहीं हो रहा है?
हाँ झाला रिकॉर्डिंग रिकॉर्डिंग
चाल दो सर।
मेल अरे अभी रिकॉर्डिंग मीटिंग करने के बाद
हेडिंग का टाइटल क्या दिले? टाइटल क्या दिया? हाँ ठीक है, लोग पता होगा
ये ना सर मेरे को मेल किए ना आवाज बंद कर दे आवाज
तू इथेच थांबा. इथे घे, कव्हर करू. तिकडे काय दिसत नाही, इकडे काय दिसत नाही.
आता येईल
पार्टिसिपेंट
फोकस करायला
स्पीकर कर, पहले म्यूट स्पीकर
हाँ
फिर बाद में पिन करते रहे जगह में
पिन कर ऐसे ही कर लेगा ना पिन सरांना पिन करायचा
हाँ
तुमचे सर पिन डबल क्लिक करो अच्छा राइट पिन तो रिकॉर्डिंग का ऐड टू पिन कर लेगा ना इसको भी ऐड टू पिन कर देते छोड़ो सर भी लेंगे विकास किधर है
दोन तास झालं
चलेगा ना दोनों अरे लिखने चाहिए अरे स्पॉटलाइट कर रहे हैं
हाँ एक
घर पे चलो रिकॉर्डिंग चालू कर दे रिकॉर्डिंग
I was so here after the I was creating a group between the because this training is not your much that so we thought creative. I have another group in Bombay about year training where I have more than 250 to 60 students. As conducted yesterday, they were all very appreciated about my efforts because of my deputy I used to send 5, 6, and half an hour again, 6 and 5 pages. And it was so easy for them. So I continue to send them for whatever and giving training, you know, they were all successful in that. So like that way, we are also, I can create a plan outside. So between yours and one of the employees to be an activator. Now, C mine is heading that. C mine is the head is for person, be a person, be a training. And now, which I also go, that you also go, there should be only one batch. So, for instead of batch only, the training batch, the person and group. So I used to give daily 5, 6 passages every day, 5 minutes. It is my request that you should attend that passage every day. At least take dictation. If you want want, you can try. Whenever you are free in your chamber, you can take on the children with the aid of a maximum mistake this one. And then you can take one or two that only like it's only like each. So you can try whenever you bring out this and you yourself can compare how many mistakes you are committed. Next time going to give you. That way you are getting experience is getting more and more. So that is the success of my professional study because stenography is that it is like that if you read it, nothing. The more you write, the more you get experience. When I was studying, I used to, daily I used to write 200 pages, 5 books I finished. I got a dictionary. So in every page, one page nearly 300 hours. I used to write 1 month page every hour. So my teacher asked, what is the success behind your? So many students, they could not achieve so far. So the mindset that I have been provided with the books and guidance and all that. So I used to write 3 hours. So I get some now. That's what this are converting the giving to you. Because how it get something you get satisfaction. You must continue to write. Every day, 1 hour goal. But without here, then stop that. That we not say. It's such that even phrases, the phrases you study more, even language also will improve. Those phrases gives you getting a good command of language also. I am also not there in the English levels, but I am also not business study. I study the ABCD standard always. So I don't know, usually Marathi medium, but you can also do it. I can actually any Marathi medium student can also be good in English, we can use phrases and all that. We can also train, but it's not like that. So I am in Marathi, I do not know, things like that. You can also achieve your target. So that is something to guide them. It is my duty to sign all this. I will not discover the understanding.
Subject matter.
My assumption is not important. So you must so my first also, then you can achieve that. So nowadays a group has been created. So today onwards I am going to say you at least 10 passages per day in that group. With the help of earphone, you will take out. But it is not at your time. Take your own time, any time. In the evening after or also for 3 hours, 10 hours, 5 times, 10 to 15 practice. So we can practice that. Okay. Sometimes you may be getting longer dictation. That is particular subject. And also different subjects. So I will give the training where the one should have not only one subject. In all fields of law. Company law, trademark law, landmark statements and all that. Everything addition, you take on, you should get accustomed. So we are working with the judge, some civil matters. We are considering only civil matters. Then that's how most animals and criminal matters. So you should get experience. That's why I'm giving dictation to what's different passages of the latest judgments of the High Court and Supreme Court. So I will continue to use that. Okay, now you will get every day. But very that time that we should write all the passages. I have passages. I don't give it that. I will give you more 10 passages. And whatever passages I am giving, you please store in your computer. Right. Okay, that means it's not only one time. You can use today, that one. Today, tomorrow no passage. So today's passage you will pick. Repetition of the passages will help you to achieve a good in the habit instead of having to be lost. Okay. Not every day we are all using normal words. Last year, we gave you some phrases. I think you are happy with that. We are not using when you take it. Not right. Today, I shall give some phrases. First phrase also. I will tell you later. I know concentrating mathematical, concentrating mathematical case. This company magazines articles of associate. You write in your book, articles of. This is above the line, articles of associate. The article is when there is an association, you use that Shanmuga. Now we say this is circumstance. Circumstantial evidence. Circumstance. These are using for the circumstantial evidence. Circumstantial evidence. Now that I told you, counsel you can write counsel like this. The counsel for the defense like this you can write. Or counsel for the defendant like this, so you can use it also. Anyway, you can cut it also, you can use it counsel for the defendant also. Like that, counsel for the plaintiff, counsel for the plaintiff. Because these are all judges, you know, had counsel for the plaintiff, like that. I see so many people are mistaken. This is called, what is this? Bankrupt. Bankrupt. Then, bankrupt is above the line. Bankruptcy is this. This is bankrupt. Okay. Now he said that rate of interest. We use this. Instead of writing rate of interest, no, you write the rate of interest. Rate of interest. Like that, a state of affairs. Like this. State of affairs. State of affairs. Now we say who have not. We say like who have not. On the line. Who have not. Like that, I have not been able to. Means I have not. Then be. Don't use LO. Then be able. I have not been able to. Then you what? Then you say we have not been able to. Then we have not been. I have not been able to. We have not been able to. So when you use this language, your language also needed language from which you can use it. This is at all times. So at all till have the times, at all times. About the at all times. At all times. No, son, it's very ceremony. It's swearing ceremony is for that is
primary evidence. When there is evidence, short, like that, secondary evidence. Primary evidence, secondary evidence, documentary evidence. Then I am conscious. Okay. So I am conscious. You are writing separately. So I am then discovered concept surface. So I am conscious. Like that, we are conscious. Just we are conscious of the matter. Or I am conscious of the matter. Like that. This you must be knowing everybody. Bill of exchange. Bill of exchange. Like this, a bill of exchange. Instead of writing, we can use bill of exchange like this. Bill of exchange. Like that way, deal in a lady. Commercial terms we use it, bill of lady. Bill of lady. This is early convenience. We can write early convenience. These are convenience we can use. We say enclosed herewith. Instead of writing like this way, we can write enclosed herewith. Enclosed herewith. What is this word? I am in receipt of your letter. I am in receipt of your letter. Instead of so I am in receipt of your letter. You are residing. So I am in receipt of your letter. Like it, I am inspected. I am, this is the correct outline. I am inspected. So you can write, I am inspected. I am inspected to say that. You say, I am inspected. We are inspected to say, I am inspected. Now, your sincerely, you must be using this only. Your sincerely. Your sincerely. Like that, I am directed to inform you. I am directed to be silent and F N be silent. So I am directed to inform you. Like that way, I am directed to stage. I am directed to inform you, I am directed to stage. Sometimes the judges will declare for you, I think you will agree with me. So I think you will agree with. I think you will agree. Now the agreement word is like this way. Now when there is purchase agreement, you write like this. Purchase agreement. We don't write separately. Purchase agreement. We use this way. Your past details. Like this, like in this agreement, we are concerned. In this agreement, on the line. In this agreement, like that purchase agreement, in this agreement, you write that. In this agreement. When this is local, this is local representative, right? Like this, representative. Local representative. Like that way, L good, Ray, U is legal representative. This is on the line, this is through the line. Local representative, legal representative. That I told in application, no? Like this simple sample. So civil application. Application you write full. This word application is coming always. You write full application. Okay. Like a civil application, review. I might have told last time, but still you write it again. And I will tell today as I will tomorrow. I typically say that you will not. So the application comes. This civil application. This is the review application. This is a development agreement. This is a correct outline. Development agreement. So development you write, then agreement like this. Development agreement. When there is agreement, when there is a disagreement, you write disagreement. I am in disagreement with you. So I am in agreement with you, I am in disagreement with you. Okay. When we are not using party, necessary, party is theoretically about that, necessary party. Necessary like that party, necessary party. Like this is the opposite party, P surplus P then P. When there is a word party, use that phrase P. Party. Last time also told authority. So district authority. Authority you like it authority. Is that a formal party? In the number is only a formal party. So formal party. Party full of them of you. So formal party. This is years ago. If you doubt, like it goes years ago. We said this is copies. Above the line copies. Sometimes the judges use copious volume. So yeah, copious. Copious means plenty of. There is plenty of judgment. There is copious from judgment. Copious. C-O-P-I-O-U-S. I see from the judgment. That's why I using this place. Sometimes I am using it. Copious. Means sufficient. Copious. Now, measure is measure. This is a correct outline. Measure. Then this is secondary measure. Instead of you delete M, so secondary measure. Primary measure, secondary measure, primary measure, and we are all using sometimes remedial measures. We are second remedial measures. M is silent, remedial measures. We say always in the light of the, in the light of is silent, in the light of. In the light of the above bracket, we shall now deal with the following answers. In the light of, in the light of. In the light of the fact that the, she said in the light of the fact that the simple option. This is rules, yeah, everybody writing rules and regulations. So rules and so rules and regulations. You are using these rules and regulations. So use these outline. You will be comfortable while taking down. This is 1 or 2. So 1 or 2. 1 or 2. Or is silent. 1 or 2 is. Last time I told you as the case may be. So as the case M thickened dot. This M thickened as the case may be. Even judgment you can see as the case may be. Like that when the judges say be that as it may be, you can write be. You write this like this as it be that as it may be. Judges use it, no? Be that as it may be, then you shall not be. Be that as it may be. There is no short form for that. As the case may be, you can write. Each and in stenography, all the outlines you can make short forms. You have to write independent pairs. Just now I told the necessary party. When agreed, Garha will give agreed part. Agreed part. See, we are using always null and void. This is null and void. So you can use null and silent void. Null and void. Null and we have null and void. This is unless and until. Unless, null surplus encountered downward. Unless and until. Like that way, in opposite direction, until encountered downward, until and unless. Unless and until, unless and until. For the purpose. Last time I told you, you can write for the purpose. For the purpose. For the purpose. In any manner. This is the correct outline. But in any manner. Put dot in. So any category one put dot. That is in any manner. In any manner. Last time I told you, according to him. Put dot when it is according to him. Yeah. If it is Karhavda, yeah, according to me. According to me, you don't put it. According to him, you put dot. So like it shows he. Like this, taken into account. Into is silent. Taken into account. Like this, taken into consideration. Into is silent. This you are writing set aside. This is the correct outcome, but you use it set aside. Put I. You always write and judgment you not set aside. Suppose. You write this so many times and you are getting on always set aside. Say like set aside. This is taken in the account. In coming to the conclusion. So in coming to the conclusion. In coming to the silent, in coming to the conclusion. That's a phrase. In coming to the conclusion, we have referred to the following as above aspects. So in coming to the conclusion. Here, now you must be using development agreement like this. This is the correct outcome. But the development agreement. Development means development we welcome. Now, power of attorney. Power of attorney is like that. So we can write power. When there is power, we write power of attorney. This is between the parties. Like parties, you write between the parties. Accommodation is state if it is housing accommodation like this. When there is housing, then we shall have housing accommodation. We use correct outline always. That will give you good speed. Like this way, you say this is what civil chamber summons. Like this way you write. Like an affidavit in rejoinder. Affidavit in reply. Affidavit in reply, you use array. Affidavit in rejoinder, read this. It is only. It is only. Like that, it is essential. Sure, it is essential. So, right, it appears that the I shall assure you. I shall assure you. Shall assure you. I shall assure you. This is in relation to the. In relation to the. So, in consultation with the, right? Use this. In consultation with. In consultation with. This is again like this, again and again. Again and again. Like that way, more and more. More liquor and cut. More and more. More and more. I'm not giving much, but I'll start with detail. If you write, I like this. Slowly, very well. And then I through the WhatsApp, I will send like this. It's a passage. This is the outside. That passage out. So every day I used to send it. So you practice that. These are correct outside. This every day I will send 3-4 pages. So you practice 1 or 2 times. Then after 1 month, 2 months, you are usually going to good outside. It's a good outside. This through the WhatsApp, I am going to say. For this, I have also studied. I will spend 5 months. But anyway, I will help you with some extent. So that you should come up with everything. You will be able to another one within 6 months. That is my intention. The next day, academic words will be used at one. We are of the opinion that while the primary duty of constitutional courts remains the control of power, including setting aside of administrative actions that may be illegal or arbitrary, it must be acknowledged that such measures may not singularly, singularly address repercussions of abuse of power. It is equally incumbent and right out in front. Yen is going to be inherent. Yen is going to be inherent upon the courts and the secondary measure to address the injurious consequences arising from arbitrary and illegal actions. This duty is to take reasonable measures to restitute the way surplus we have in the tax. Restitute. The injured is our constitutional purpose. That is how we have read our constitutional text, text, and this is how we have built our precedents on the basis of our objective to secure justice. In public law proceedings, when it is realized that a prayer in the petition is unattainable, unattainable due to passage of time, constitutional courts may not dismiss the request
proceedings on the ground of their perceived, first we have the futility, disability to the life. In the life of litigation, passage of time can stand both as an ally, and adversary, we were surplus about that. Our duty is to transcend her circular and her surplus encounter, transcend the constraint of time and perform the primary duty of a constitutional court to control and regulate the exercise of power or arbitrary action. By taking the first step, the primary purpose and object of public law proceedings will be subserved. The second step relates to restitution, restitution. This operates in a different dimension. Identification and application of appropriate remedial measures poses a significant challenge to constitutional courts largely attributable to the dual variables of time and limited resources. The gap between the induced legal or arbitrary action and their subsequent adjudication by the courts introduces complexity and complexity in the provision of restitution. As time elapses, the status of persons, possession, and promises undergoes transformation, directly influencing the nature of relief that may be formulated and granted. The inherent difficulty in bridging the time gap between the illegal induced action and restitution is certainly not rooted in deficiencies within the law or legal jurisprudence, but rather in systematic issues inherent in the adversarial, adversarial judicial process. The protracted timeline spanning from the filing of a petition, service of notice, filing of counter affidavits, final hearing, and then the eventual delivery of judgment coupled with subsequent appellate procedures delays. Take for example, this very case, the petition was filed against the action of the respondent denying appointment on 25th May 2017. The petition came to be decided by the single judge on 24th January 2018. The division bench on 15th January 2018, and then the case was carried to the court in the year 2019, and we are deciding it in 2024. The delay in this case is not unusual. We see several such cases when our final hearing board moves. Appeals of more than 2 decades are awaiting consideration. It is discussing, but certainly not beyond us. We must and we will find a solution to this problem. Placed in the light of the about judgment, it is now to be reconsidered as to the measures of restitutive relief which can be provided to the appellant in the present case. In the light of the discussion from observation made here about a meritorious candidate from student who has been denied an admission in a media course illegally or irrationally, irrationally by the authorities, for no fault of it, and who has approached the court in time and so as to see that such a meritorious candidate may not have to suffer for no part of case. We enter the reference as under. Take in a case where candidate student has approached the court at the earliest and without any delay, and that the question is with respect to the admission in medical colleges, all the efforts shall be made by the court concerned to dispose of the proceedings by giving priority and at the earliest. Under exceptional circumstances, if the court finds that there is no fault attributable of the honorable to the candidate and the candidate has pursued, we raise a pursued his legal right expeditiously without any delay, and there is fault only on the part of the authorities, and or there is apparent breach of the rules and regulations, as well as related principles in the process of grant of admission, which would violate the right of equality and equal treatment to the competing candidates, and if the time schedule prescribed 30th September is over to do the complete justice, the court under exceptional circumstances and in the rarest of rare case direct the admission in the same year by directing to increase the seats. However, it should not be more than 1 or 2 seats, and such admissions can be ordered within reasonable time, that is within 1 month from 30th September, that is cut-off day, and under no circumstances this court shall order any admission in the same year beyond 30th October. However, it is observed that such relief can be granted only in exceptional circumstances and in the rarest of rare cases. In case of such an eventuality, the court may pass an order cancelling the admission given to a candidate who is at the bottom of the merit list of the category, who, if the admission would have been given to a more meritorious candidate who has been denied admission illegally, would not have brought the admission if the court deals it with and proper. However, after giving an opportunity of hearing to a student whose admission is sought to be cancelled, in case the court is of the opinion that no relief of admission can be granted to such a candidate in the very academic year, and wherever it finds that the action of the authorities has been arbitrary and in breach of the rules and regulations, or the prospector affecting the rights of the student, and that a candidate is found to be meritorious, and such candidate has approached the court at the earliest, and without any delay, the court can mold the relief and direct the admission to be granted to such candidate in the next academic year by issuing appropriate directions by directing to increase in the number of seats and may be considered appropriate in the case and in case of such an eventuality, and in case found that the management was at fault and wrongly denied admission to the meritorious candidate, in that case the court will direct to reduce the number of seats
in the management quota of that year, meaning thereby the students who were denied admission illegally to be accommodated in the next year out of the seats allotted in the management quota. Grant of compensation could be an additional remedy, but not a substitute. We have here a substitute for restitution remedies. Therefore, in an appropriate case, the court may award the compensation to such a meritorious candidate who, for no fault of his, has to lose one full academic year and who would not be granted any relief or admission in the same academic year. It is clarified that the opposite directions were paid to admission in MBBS course only, and we have not. That way, postgraduate medical course paragraph. The learned senior counsel appearing for the petitioner has submitted that the only issue which was to be resolved by APDS as the name, and this court was with regard to the payment due because of change in law which was held to be the actual cost of alternate cost imported gold and certified by the auditor, these are auditor, minus landed cost of domestic cost. There was no other dispute which was to be resolved by this court. Learned Senior has submitted that it is now contended by the respondent that certain payments have been made by the respondent, yet according to the Learned Senior Counsel was towards regular payment on the basis of domestic linkage, code, and nothing else. Since the change in law ground of petitioner has been accepted by all the authorities, and this court also confirmed by the dismissal of the review application filed before this court, the question cannot now be reopened. Read through the language we have reopened. At this stage, it is the submitted that since the actual cost of alternate code, so imported code, hence was submitted by the petitioner, has been duly certified by the auditors, which has not been disputed by the respondents. The payment is going or to have been made, and since the same has not been paid, the respondents are liable for contempt. Because the contention of the Learned Senior Counsel of petitioners is that the claim of the respondents that they had paid certain amount towards energy charges regularly month by month, which included certain amount of price of gold, charges cannot be accepted as at that stage, that is in the year 2013, the respondents had not accepted the claim of the 8 petitioners with regard to change in law and the assertion now being made by the respondents that they had paid certain amount after partially we were approached the party. Accepting the change in law clearly cannot be accepted as this issue had never been raised by respondents in any proceedings earlier, as the respondents and in fact throughout contested that the petitioner is not entitled to the change in law benefit paragraph. The thrust of the contention is that the respondent number 2, on behalf of respondent number 1, had assured that the interest charged by respondent number 1 is as per the retail
prime lending rate to be notified by RBI. As such, the interest which was indicated at 7% can be altered only if the RBI had altered the rate of interest and not otherwise. So, in the agreement, it is contained that the rate of interest would be as per the prime lending rate of interest of respondent number 1. The same is contrary to the assurance that was held out to the appellant that such adjustable rate of interest agreed is only when the rate of interest is varied by the RBI and not as per the interest to be varied by respondent number 1. The learned senior counsel for the appellant in that regard has placed strong reliance on the email dated 5th October 2005 to conduct that such assurance was made to the appellant. The learned senior counsel for the appellant has relied to rulings wherein the issue considered was with regard to an exclusion clause in an insurance policy. Insurance is insurance policy, which materially altered the nature of the contract. It was observed in this regard that insurance contracts are standard form contracts wherein the insurer, being the party, dictates its own terms and conditions, and the consumer has weak bargaining, bargaining about the power, and as the contract are one-sided. The concept of freedom of contract loses some significance in a contract of insurance. Such contracts demand a very high degree of prudence. Good faith disclosure and notice on the part of the insurer being different as set of the doctrine indicator of fairness. The bench consisting of 2 honorable judges was of the opinion that one cannot give a restrictive or narrow interpretation to the provisions relating to unfair trade practices as given under the Consumer Protection Act. This court's finding against one of the parties was that the systems of unfair trade practice has to be transformed into an adequate relief in favor of the other, particularly in the light of Section 14 of the Act. Once the State Commission or the National Commission, as the case may be, come to the conclusion that the term of contract is unfair, particularly by adopting an unfair practice, the agreed party has to be extended the relief, which is further strengthened by Section 47 of the Act. It was also observed that under subsection 2 of sections 49 and 59 of the Act, the State Commission and the National Commission respectively may declare any terms of the contract being unfair to any consumer to be null and void, and there exists ample power to declare any terms of the contract as unfair if, in its opinion, its introduction by the insurer, insurer, has certain elements of unfairness. The dispute in the said case was regarding amenities promised by the real estate developers in their advertisement, which were not delivered by them. It was noted that once the commission arrived at a finding that the respondents therein were actual in their approach and had even resorted to unfair trade practice, it was its obligation to consider the appellant's element objectively and upon application of mind and thereafter give its reasoned decision. he account the appellant and not forfeited, FTR forfeited any right by registration of the same deeds, and if indeed the content were unlimited. In providing any of the facilities and promise in the advertisement, it was the duty of the commission to set things right. In the third case, in those facts and circumstances, it was found by this court that fraud was committed by an officer and employee of the post office. It was held that post office functions through its employees and individuals are capable of being dishonest and committing acts of fraud or wrong themselves or in collusion with others. Such acts of post office employees, when done during their post employment, are binding on the banks of post office at the instance of the person who is damnified, damnified by the fraud and wrongful act of the officers of the bank, and such acts within their course of employment will give their right to the appellant to legally proceed for injury, as this is their only remedy against the post office. Thus, the post office, like a bank, can and is entitled to proceed against the officers and the loss caused due to the fraud, etc. But this would not absolve, these are not apparently absolved. Now, from their liability, if the employee involved was acting in the course of his employment and duties, but a perusal of the above noted cases, it would disclose that there are circumstances where certain aspects were contained in the agreement in question, but a contention was raised contrary to the same, and this court had rejected such contention. I can give any comment? No. Yeah. Not getting. I explained that in this video on the definition. But after the news is very active and we can walk very only for that purpose I am giving the detail. You have to read it. And these models you have to read it. Now you read it and then you have to read. Okay. It was held that while English jurisprudence, there is surplus for the enunciation, is clear on the aspect of correspondence, using its significance once the content comes into execution. A formula cannot be applied here, as there may be people from different states and different languages and their mother tongue whose wishes can be made into a contract which is drafted and concluded in a foreign language. Having perused the precedents on which the lines was placed, we are of the opinion that the same does not come to the aid of the appellant. In the instant case, at the outset, civil application number 1.95 of 2023, it is to be noted that the respondent number 1, being a bank and as a corporate body, would be bound by its policies and procedures with regard to lending, and recovery. In that regard, the applicability of the right interest to be charged is also a matter of policy and cannot be case specific unless the individual agreement entered into between the parties indicate otherwise. We have carefully perused the counterfeit filed by the ministry before the National Green Tribunal. The said affidavit does not deal with ground at all. It does not specify or set out reasons for concluding that in the public interest, the requirement of application of prior notice was needed to be discussed with. It is pertinent to note that before the issue of second notification by which appendix, we have the UPK appendix was incorporated, the procedure of inviting objections to the draft notification was followed and the objections were considered. There is no reason to dispense with this important requirement before publishing the impute notification. Article 21 guarantees a right to live in a free pollution environment. The citizens have a fundamental duty to protect and improve the environment. Everywhere, they would enhance the environment. Therefore, the participation of the citizen is very important and it is taken care of by another come to raise objections to the proposed notification. After all, citizens are major stakeholders in these matters. Their participation cannot be prevented by casually exercising the power and substitute force of Rule 5. In the present updates, the question of law has been incorporated regarding the illegal invocation of the power and the substitute force of the Rule 5 of the EE rules. In the grounds of the challenge, the ground has been taken explicitly, explicitly on this aspect. We have perused the counter filed by the ministry in these appeals. We find from the civil appeal number 1628 of 2029 to 28 and 29 of 2021, page 27 of 32 affidavit that contention raised regarding the illegal invocation of power under subrule 4 of Rule 5 has not been dealt with. We are not going into the question of whether it was necessary for the central government to specify reasons in the impute reason for impute notification itself. Why? We came to the conclusion that in the public interest, the requirement of public notice should be dispensed with. Anyway, well, jurisprudence. Once the contract formula is not brought for this. Different. Because culminate, culminate, NP, culminate, culminated, culmination, culminate, culminated, culmination. Okay. Into a contract which is and concluded.
College, now next, you read it. Next, you read it. You are not, you are unable to read, then you read, but you having produced. Then having produced presidents. Eight. No, sorry. Maybe you did two. So, put it on. Eight. Lengthy, and how many you put out it? Lengthy. This is the length, lengthy. Appropriacy and fairly. You correct the you correct it. You correct mistake. We have carefully. Regularly like green regular. Green regular. Actually, you write also.
Ground account, it does not specify cost account reason for concluding that in the computation requirement of the communication of the balance sheet was noted. Need to break the
No, I don't need it. This is not that above the line. This is needed is like footnote.
It is pertinent to note that. It is pertinent to note that in the issue of the second notification package appendix so the procedure of the notified of.
When you write incorporate this anchor, when you write incorporated footnote like this. Past tense. Whenever there is past tense, I also commit this. You also the footnote. Like that, I told you, informed like this. Okay? Like that, footnote. Past tense, that will not commit mistake.
Objection to the application was followed and objection were considered. There is no reason to disagree with this important.
Important requirement, no? I don't know. So important, but right, requirement. Now I like it is required like this. Now record last night I told you, put like this. It's important because.
Conditions include Article 31 guarantees the right to live in a way. The divisions are
Environment and we full outline environment. If it is environmental, upward environment.
Environment, therefore the participation of the citizen is very important to be taken care of by allowing them to after adults citizens are major states.
Take coordinates. Take coordinates.
In this manner, the participation cannot be
Their participation. But these two here, this may are prevented. Is the question that using present tense? The question of law. Incorporated, and to be incorporated to law regarding education. Not explicitly, the case surplus explicitly, full outline. Case surplus full, supposed to be upward explicitly.
But 28 and 29 of 2021, and page 27 of the Dictation is regarding the illegal invocation of power under section 4 or 5 has not been done.
It has not been that is done here. How do you plan? Yeah, no.
Then you get the question.
They are not showing.
That was necessary. Central government states.
Last time I told you a question like this here. So we are not going into the question. Into the question.
Some degree of confusion that
You want to increase the speed? No, no, same level.
Pronunciation is not. That's why the omissions are there.
Okay, like through the WhatsApp, you will answer most of them. That's more. This is not only sometime I'm not going down, but I'm giving you from the WhatsApp page, that will be more beneficial. But we must pay.
Something whether we can just properly.
Now voice now, and we are again after the overall I have more dictating. I have to see my. But anyway, I'll give it to people. But I don't know whether you will be able to take down. When I speak like this way, you can take down. You can hear. I give 2 minutes. Let's see what happens. Take up. The drastic decision to invoke subrule 4 of rule 5 was made without any application of the mind. Hence, the decision-making process has been vitiated. The downward we have. The imbued notification was issued 2 days after the nationwide lockdown was imposed due to the COVID pandemic. At that time, the work of projects such as road, pipeline, etc. had come to a halt. So there was no hurry to modify the notification. Apart from the fact that no reasons have been assigned in the counter affidavit filed by the central government for coming to the conclusion that in the public interest, the requirement of prior notification of notice was required to be dispensed with. We fail to understand the undue case shown by the government in issuing the impugned notification during the nationwide lockdown. Therefore, the inclusion of item 6 of the appendix will have to be held illegal. We have already given reasons for not dealing with the challenge to item 7 in the impugned notification. There is one more important ground for striking down item 6. But for item 6 in appendix 9 to the impugned notification for extraction, extraction, sourcing or borrowing of ordinary air for projects, prior EC approval would have been required in terms of the notification. The very object of issuing the first notification incorporating the mandatory requirement of obtaining for project was that the damage to the environment must be minimized while implementing projects, while an exception is sought to be carved out by incorporating appendix 9 to the requirement of obtaining EC. In the first EC notification, the exception must be specific. Item 6 grants exemption for extraction or borrowing of ordinary earth for the project such as road, pipeline, etc. There is no specification about the quantum of ordinary earth which can be extracted on the basis of the exemption. There is no specification of the area which can be used to extract ordinary earth. It is also not provided that only that quantity of ordinary earth, which is required to implement the project is exempted. Importantly, the projects have not been defined. Without the definition, it is difficult to imagine which projects will be termed these projects. The term project is very well established. The process to be adopted for excavation has not been set out. Thus, item 6 is a case of completely unguided and blanket exemption. There is no provision for setting up an authority which will decide whether a particular project is covered by item 6. As stated earlier, during the pendency of the appeals, an amendment was made to item 6 by the notification dated 30th August 23. Even the amended impugned notification does not elaborate on the concept of project. The only addition to item 6 is that the extraction or borrowing shall be subject to compliance with SOP and safeguards issued in this regard from time to time. The authority to issue the SOP and safeguards has not been specified. No provision has been made to enforce the SOP and environmental safeguards. No restriction is imposed on the quantum of ordinary earth which can be extracted for the projects. Therefore, even the amended item 6 continues to suffer from the same works of arbitrariness which Article 14 of the Constitution of India prohibits. The latter additional Solicitor General placed reliance on the office memorandum dated 21st August 2023. It provides that before carrying on activities mentioned in entry 6, the project proponent proponent must notify the State Pollution Control Board. The State Pollution Control Boards are required to monitor the compliance status of the safeguards. Hence, on account of the violation of Article 14, Item 6 in the impugned notification, as well as the amended impugned notification, will have to be struck down. As noted earlier, the object of the Act is to protect and improve the environment. Apart from the illegality committed, illegality committed by the non-compliance of Sub-Rule 3 of Rule 5 of the EQ rules, the exemption granted without incorporating any safeguards is completely unguided, incorporating and arbitrary. Grant of such blanket exemption completely defeats the very object of the Act. In paragraph 8 of the impugned order, which we have quoted earlier, the tribunal observed that the blanket exemption needs to be given by appropriate safeguards such as process of excavation and quantum. Therefore, in paragraph 9, a direction was issued to the ministry to revisit the impugned notification in the light of the observations made in paragraph 8. Within 3 months provided by the entity to do so, no steps had been taken to revisit item 6 of the notification. The ministry has filed an additional affidavit dated 18 July 2023, and reliance has been placed on the guidelines for mining. As far as item 6 is concerned, in the counter affidavit, reliance was placed in the office memorandum dated 8 August 2022, issued in terms of the directions in paragraph 9 of the impugned judgment. It records that item 6 shall be subject to the SOP attached to the civil appeal. We have perused the said SOP. We find that the SOP creates no regulatory machinery to ensure the implementation of the terms of implementation. Therefore, the said SOP can hardly be said to be in terms of what the tribunal ordered the central government to do in terms of paragraphs 8 and 9. Paragraph. We are not entertaining a challenge to item 7 of the impugned notification, as none of the respondents have challenged the impugned notification. They will have to implement the directions issued in terms of paragraph 9 of the impugned judgment regarding item 7. Thus, notwithstanding the specific directions issued in paragraph 8, read paragraph 9 of the impugned judgment, no safeguards have been provided, such as laying down processes, the mode and the manner of excavation and quantum. Therefore, we have no hesitation in striking down item 6 of the substituted appendix forming part of the Indian notification dated 28 March 2020 and item 6 of the amended Indian notification dated 30th August 23. Accordingly, we count item 6 in the above notification paragraph. The offense are being prosecuted for offences punishable under sections 419 and 420 of the Indian Penal Code and section 66, read with sections 43 and 66B of the Information Technology Act. The charge sheet has been filed and the trial has proceeded. By the impugned order, the High Court rejected the appellant's application. Appellant's application, full. Appellant's application. For regular bail, during the hearing of an earlier date, we were informed that the High Court recorded the examination in chief of the 12 prosecution witnesses, one after the other, on different days without recording their cross-examination. Therefore, considering this peculiar procedure followed by the learned trial judge, we requested the learned trial judge to submit a report. We have perused the report dated 11 March 2024 of the trial court, which records that by an order dated 27 June 23, a direction was issued. Direction that can go the line and attraction by the High Court to complete the trial preferably within a period of 4 months. Therefore, the charge was filed on 30th May 23 and from 25th July 23 to 7th February 24, evidence of 12 prosecution witnesses was recorded. The report records that the evidence of prosecution witnesses was recorded in the presence of the appellants, but the advocate was not present as they had not engaged any advocate. Paragraph. In our view, the trial court ought not to have recorded the evidence in this action before recording the examination in chief of the first prosecution witness after finding that the appellants accused had not engaged any advocate. The trial court ought to have provided a legal aid advocate to the appellant accused so that the evidence of the prosecution witnesses could have been recorded in the presence of the advocate representing the appellant accused. Paragraph. The order sheet enclosed with the report does not record that the appellants declined to accept the services of a legal aid lawyer. When the examination in chief of a material prosecution witness is being recorded, the presence of the advocate for the accused is required. He has a right to object to a leading or irrelevant question being asked to the witness. If the trial is concluded in such a manner, an argument of prejudice will be available to the accused. This is a warrant case. In a warrant case, in view of the proviso to subsection 3 of section 24 of the CRPC, the learned magistrate, by recording reasons, can permit cross-examination of a witness to be postponed till a particular witness or witnesses are examined. However, in the present case, no such order was passed by the learned magistrate. The normal rule is that witnesses shall be examined in the order laid out in section 128 of the Indian Evidence Act. The learned judge seems to have adopted this method only because the High Court had fixed a time-bound schedule for the disposal of the case. He could have always sought an extension of time from the High Court. Therefore, recording only the examination in chief of one prosecution witnesses without recording cross examination is contrary to the law. Considering the facts of the case and the nature of the offences alleged against the appellants, and also considering the fact that the appellants have been in custody since 8 January 2023, we find that a case is made up for enlarging the appellants on a enlarging and appellant on bail. To avoid any argument of prejudice, we direct the learned additional chief metropolitan magistrate to conduct a fresh trial by again examining the prosecution witnesses who have been already examined and the learned counsel appearing for the appellants state that a direction may be issued to the trial courts to provide legal aid to the appellants. Hence, we allow the civil appeals by passing the following order. We direct that the appellant shall be produced before the trial court on 27th March 24 at 10:30 a.m. On that day, the trial court will appoint a legal aid advocate to espouse, shorter speech circles, espouse the cause of the appellants. We direct the trial judge to enlarge the appellants on bail and appropriate terms and conditions till the conclusion of the trial. After giving an opportunity of being heard to the learned prosecutor on the terms and conditions of the bail. The conditions of bail shall include the conditions of the appellants surrendering their passports before the trial court. We direct the trial court to hold that trial by examining the prosecution witnesses. How does it? I'm going to verify all your things around those.
The tenant has no right that his tenancy should be terminated by a notice. Such a right may be given to him by his contract with the landlord. In the absence of a contract or usage, section 106 of the Act requires that a tenancy should be terminated by a notice. This provision is for the benefit of both the landlord and the tenant. As pointed out in the said case, section 106 itself opens with the words in the absence of a contract or local law or usage to the contrary. These words show that the requirement of notice under section 106 is not rigid, where they have rigid. Parties may enter into contract to the contrary at the time of entry into a lease. Since the lease itself is based on contract, the parties may agree to vary its terms by a subsequent contract. One of the parties may even agree to abandon abandon a right given to it by section 106 in the absence of a contract to the contrary. Means the requirement of notice can be thus be waived. May have to be there. By an agreement between the parties, it would be reasonable to think that it would also be waived by such contract as would be the evidence of intention of the parties. Section 106 itself contemplates that the termination of the lease may come about otherwise than by the below notification. Thus, viewed the requirement of notice under section 106 is essential for the benefit of the parties. The requirement is not mandatory. When we have the upper and section 106 is the show that the tenancy may be terminated in some other way. That is why this statutory right of the tenant must be held to be capable of being waived. On the contrary, certain statutory provisions give a right or an immunity or protection to certain persons as a matter of public policy. Such statutory provisions cannot be waived. This is why, for instance, prohibition against the subletting, of the premises by a tenant was held incapable of being waived by the landlord. Similarly, when the court does not have jurisdiction to deal with a matter, parties cannot give it such jurisdiction, and therefore the objection to an act of jurisdiction cannot be waived as is felt in the said case. For the same reason, a tenant cannot agree to waive statutory protection given to him by the provisions of section 48 of the Act against eviction of provisions. It is clear, however, that the requirement of the notice under section 106 is not based on any mandatory provisions based on a public policy. They can therefore be waived. Waiver of course implies that a person may be waived or waived. His right is aware of the right. The right given to the tenant under section 106 of the Act, namely the provisions of section 40 of the Act, was a matter of common knowledge, especially because it was a statutory right. It would appear from the course of litigation in this court that the tenants were not generally raising a plea of want of notice under section 106 of the Act in defense to a petition for eviction by the landlord. They started raising these pleas mostly after the decision of the Supreme Court. As pointed out by us, however, the Supreme Court has been expressing the view that provisions of section 106 of the Transfer of Property Act were not
superseded, superseded suppose we have superseded by the provisions of the various acts from their decision. We have also pointed out that the mere fact that in the said case, the Supreme Court was dealing with a statute which contained a clause similar to the clause in section 14 of the Act, which cannot be used as a point of distinction between those statutes and other statutes dealt with by the Supreme Court. This view finds support in the relevant provisions of the Civil Procedure Code. Under Order 6, Rule 4, a party which relies on a particular circumstance such as misrepresentation, willful default, etc., and in all other cases where particulars will be necessary, beyond such are exemplified, in the form of appendix. The particulars shall be stated in the appendix. The compliance with the provisions of section 106 of the Transfer of Property Act is extremely important in proceeding with the landlord and tenant. It is therefore absolutely necessary that the party which relies upon the compliance or non-compliance must give the particulars in the pleading. And Order 6, Rule 6, the party interested in stating anything about the performance or otherwise of a condition precedent must take the pleading about it. And Order 6, Rule 6, it is sufficient to allege the notice and the fact. It is not sufficient for the defendant to deny generally the ground alleged by the plaintiff. Under Order 8, Rule 4, and evasive denial is not sufficient and may amount to admission. Ordinarily, the landlord applying for an eviction of a tenant must believe that the tenancy has been terminated. If the tenant does not make the plea that the suit or the application is untenable due to the termination of the contractual tenancy, that he would be either deemed to have admitted the allegation of the landlord or to have waived the benefit of the protection of section 106 of the Transfer of Property Act. If, however, the landlord fails to plead the termination of the contractual tenancy, then the question arises whether his decision for the eviction of the tenant would be liable to be rejected for want of a course of action. In our view, the answer to this question should be in the negative. For, in addition to the termination of contractual tenancy, some other facts, such as wrongful acts of a tenant, also constitute a cause of action for eviction. The mere omission to mention the termination of a tenancy would not amount to a non-disclosure of the whole of the cause of action. Or a part of the cause of action still be amount to a non-disclosure. The question whether the failure of the tenant taking the plea of non-compliance with section 106 of the waiver of the said plea and whether the landlord is thereby exempted from the necessity to comply with section 6 of the Act can be answered only after the nature of the compliance with section 106 Act is understood. We have stated above that such a compliance is not a jurisdiction condition, nor thus the jurisdiction of a court or the rent controller depend on the satisfaction of this condition. The complaints must, however, be pleaded by the landlord. But the failure to make such a pleading would not ordinarily amount to non-disclosure of the cause of action itself. It is for these reasons that we are inclined to the view that the failure of the tenant to raise the objection regarding the non-compliance with section 106 of the Act at an early stage of the litigation would amount to a waiver of the plea, facts and circumstances of each case when the conduct of the tenant would amount to such a waiver. The greater the delay on the part of the tenant in raising such a plea, the greater the probability of his conduct amounting to waiver. In the said case, the majority of two general judges against the dissent of one general judge took the view that the tenancy must be determined before the petition for eviction under the Act is filed by the landlord. This view is in accordance with the finding given by us on question number 1. We also need not agree with the majority view that it was for the landlord to mention in his plea the fact of determination of the contract tenancy as one of the facts consisting the cause of action which he is required to state under Order 7 Rule 1 of the CPC. Their lordships, however, further observe that if the plaintiff landlord fails to make such a pleading, then the tenant can take the plea of non-compliance with section 106 of the Act for the first time. In second appeal, we find ourselves unable to agree with this observation of their lordships for the reasons already stated above, namely the plea regarding the termination of the contractual tenancy does not constitute the whole of the cause of action for a petition for eviction, with the result that facts consisting of arrest of the cause of action, the non-compliance of section 106 of the Act does not go to the jurisdiction of the court. It is to be further noticed that the statutory requirement of notice under section 106 of the Act is solely for the benefit of the parties to the contract of tenancy. There is no public policy behind it. This is why the requirement can be waived by the parties. This argument is a necessity of notice under section 80 of the Civil Procedure Code, which may be said to be based on public policy in as much as the government has to be given time to consider the claims made against it, so that the government may admit or settle down an unnecessary litigation, and the waste of public time and money should be avoided. Okay. Now, you have to take all the numbers. Very good. Look towards look to carry and number one. See that I cannot be. Let people remember he and anybody. I am outside. I don't give it dictation. This is only nothing. That is more into what? They are to write down writing. I don't do that. But outside, okay, I noticed that. That's me going check everybody out. I want to do outside your paper, your standard with the red line. And very good. And sending particles, like this. If you write only what I am writing, if you write some passage on 2-3 weeks, then you realize it's a character. I will send this. Daily I will send it. You have to practice every day. When I totally make all of this. Second last time you do you number it, you will take it. And you coordinate. Thank you very much.
Thank you.
Sir, आपको writing part लेके आना, आपको कुर्सी पे बैठ के लिखने के साथ ही पढ़ना। अपना राइटिंग घर लोग पे लेके writing part लेके आना। What's the lead? मैंने 2 घंटा जैसे 3 घंटा कंटिन्यूस सीखना सीखा सो आपको फिर तुम लोग जजमेंट देगा ना जितना आधा घंटा 1 घंटे थोड़ा प्रोग्रेस आ रहा है हाँ पूरा पूरा 10 मिनट का नॉन स्टॉप मत थोड़ा
That we have created a group for CMA is that I told her to create a group. I think we have to give the numbers to the public and the WhatsApp group. Okay. In that WhatsApp group, I am going to give dictation every day, 5-6 per day. That you must take 5 minutes, like half an hour you have to spend for me every day. It is my intention that within 6 months you should be expert, expert. I will see, and in that, and then when I find that, I also will give like this way. One set passes, and one set around next. That's dictation there. Step of that. Then I said 85 pages. In addition to dictation, you also practice this. Not one time, 2 times. This is a very complex. So, once you practice this for 2-3 months, then you will become. Okay. So through the WhatsApp group only, you know, we are going to I'm going to do. So the group has to be created. So you give the names to mobile, WhatsApp mobile. You know, Sima, otherwise, I don't know, Sima, you know, Sima. The number that is number Sima about it. We do it today only. I don't want to delay now. I am going to give it today on the dictation. What's the dictation? And then outline to know. Okay. Complete. And it's not great, though. That I did it not for that last 10 days.
This is the article, no? Article. The article, no? When you say articles of association, right? Articles of association. Right? This is circumstantial evidence. Evidence. Surplus rate. It is circumstantial evidence. Circumstantial like that. Instead of writing the circumstantial evidence like this. Counsel for the defendant. Like this, we can write it down like the counsel for the defendant. Counsel for the plaintiff. You can write like this. We are using always. You can write counsel for the plaintiff also like that. But you must remember, it's the counsel for the plaintiff. This is rate of interest. Instead of writing a rate of interest, now you write a rate of interest. Rate of last maybe dictation now writing difficult. This is state of affairs. State of affairs. State of affairs. Like that, we who have not been, like that, who have not been, who have not been. I have not been able to. Like I have not been able to do this. We have not been, I have been not able to. We have not been able to. I have not been able to. We have not been able to. That is at all times like this. So at all to have the M surplus at all times. At all times. Like that way, at all events. We can have the surplus at all events. The deed of trust, deed of the correct outcome. So instead of writing like this, deed of is silent, deed of trust, deed of trust. You must be using all this, but stay and repeating it. Examination in chief. Examination in chief, like this. This is judgment summons. Judgment full shortcut, judgment summons. This is like a memorandum of association. Like I told you, articles of association, no? Like this memorandum of association. Documentary evidence. Full outline, documentary evidence. This is primary evidence. Primary evidence. This is secondary evidence. Primary evidence, secondary evidence. What is this? I am conscious. I am conscious. Like that, we are conscious. Judges say, no, we are conscious of the matter, and I'm conscious of the matter. We are conscious of the matter. You are writing this bill of exchange. Like that, bill of lading, you can write this on the line. Bill of lading, bill of exchange, bill of lading, bill of exchange. When you say convenience, this is the correct outline. Okay? But when it is early convenience, we end. Early convenience, convenience. I am instructed like this, you know. So I am instructed. I am instructed. I am instructed. This I am directed to stage. I am directed to stage. See, I am directed to inform you. It's an English, English command also. Let me use this. I am directed to stage. I am directed to inform you. This is I think you will agree. I think you will agree with me. I will say, right. I think you will agree with me. So instead of writing separate, you write, I will say. When there is an agreement, Gerhard and when if it is purchase agreement, you write like this. Purchase agreement. Like this, in this agreement. In this agreement. When you say development, this is a correct outcome, development. When it is, you can write like this, development, decut. Then development agreement. Development agreement. You write 5 lines each in every outline like this. Last time I told you in application, review application, you write, follow this only application, okay? Like this civil application, review application, miscellaneous application, interim application. So print, use print for the application. Okay. This is necessary party. Party use P, necessary party. Necessary party. Like this opposite party. Opposite party. Like that formal party. Yeah, how do you put dot formal? No, yeah, formal party. Formal party. Like that. Years ago. Yes, now you know writing separate outline. Last time I saw somebody write this is copies. When there is a word copious under the ER. So COPIOUS. I saw some of the judgments of that. Copious means sufficient. Copious from words, copious from judgments. Copious, COPIOUS, copious. Outline is same, but you put this one. Wow. Primary measure के लिए शर यूज करना M silent measure primary measure like this secondary measure primary measure secondary measure like that remedial measures we are using this remedial measures. Remedial measures were taken by the court to come to the conclusion like that. Remedial measures. Right? In the light of the, instead of writing in the light of, in the light of the, in the light of. This rules and regulations. Instead of writing this, rules and regulations. You write this rules and regulations. 1 or 2, or is silent. 1 or 2, 1 or 2. I told you this application party necessary party. Let us start. You say aggrieved party. There have put dot. So the aggrieved party. These are commonly used in the judgments. Write each and every outline 5 lines. This is until and unless. Until and is silent unless. This is unless and until. This until and unless. So we are using this unless and until. For the purpose. This is an outline. So for the purpose, purpose surplus, for the purpose. In any manner, put any capital. In any manner. In any manner. This is according to me. According to me. Then according to him, dot, put dot, him. Like that, you know, to be is not required, but to him, put dot. This is taken into account, taken into account. This is taken into consideration. You are right, set aside is like this is a correct outline, but you can write surplus is surplus, set aside. I if you want. Set aside. Always set aside. In coming to the conclusion. Come out is silent. In coming to the conclusion. In coming to the conclusion. Development is correct outline is, but you can use this development. Development. And development agreement is like this. Development agreement. So between the parties is surplus. Then it is required. It is required rather than put past tense this. It is required to be noted. That is often used. It is required to be noted. So it is required. Required I use this. They are required. So the power of attorney, P download term use them. Power of attorney. Power of attorney. Accommodation is K D Shanuk. Then when there is housing accommodation, D Shanuk. These outlines and these values are some outlines. In the group, you can ask any outline, you can ask, I will reply to that. What is this? Huh? What is this? What is this? Affidavit examiner. What is this? It is only. It is only. And if it is surplus, sure, it is essential. It is essential. It appears that you are writing like this, it appears that. It appears that. Okay. I shall assure you. Assure you means assure, like this, I shall assure you. I shall assure you. This is in relation, sorry, in relation to the, okay? This, if it is in surplus, in consultation with you. In relation to is only like this way, then in consultation with you. In relation to, in consultation with you. It's a, we are using again and again, like this, again, then to cut. So again and again. So like a planning commission. When it is a planning, when it is planning commission, like this. Like that again and again. Now you say more and more, like this, more and more. More and more. I have some difficult words outline. I will send it to you on WhatsApp. You write this and every word outline. I give some suggestions.
We are of the opinion that while the primary duty of constitutional court remains the control of power, including setting aside of administrative actions that may be illegal or arbitrary, it must be acknowledged that such measures may not address repercussions of abuse of power. It is equally incumbent and disjoint we have removed upon the courts and a secondary measure to address the injurious consequences arising from arbitrary and illegal actions. This duty to take reasonable measures to restitute res surplus T have the attached. Res surplus T have the attached. The injured is our constitutional purpose. That is how we have read our constitutional text, and this is how we have built our precedents on the basis of our objective to secure justice. In public law proceedings, when it is realized that the prior in the petition is due to passage of time, constitutional courts may not dismiss the proceedings on the ground of their perceived, we have futility, futility. In the line of litigation, passage of time can stand both as an ally. Our duty is to change the constraint of time and perform the primary duty of a constitutional court to control and regulate the exercise of power or arbitrary action. By taking the first step, the primary purpose and object of public law proceeding will be subserved. Paragraph. The second step relates to restitution. This operates in a different dimension. Identification and application of appropriate remedial measures poses a significant challenge
to the constitutional courts largely attributable to the given variables of time and limited resource. The gap between the induced illegal or arbitrary action and their subsequent adjudication, they have to get under adjudication by the court introduces complexities, convertibility surplus in the provision. As time elapses, the status of persons, possession, and promises undergoes transformation, directly influencing the nature of relief that may be formulated and granted. The inherent difficulty in bridging, the time gap between the illegal immune action and restitution, is certainly not rooted in deficiencies within the law or legal jurisprudence. There is nothing per the emphasize jurisprudence, but rather in systematic issues inherent in the judicial process. Thank you, madam. The protracted timeline spanning from the filing of a recognition, service of notice, filing of stronger affidavit, final hearing, and the eventual delivery of judgment coupled with subsequent appellate procedures delays. Take for example, this very case, the petition was filed against the action of the respondent denying appointment on 22nd May 2017. The petition came to be decided by a single judge on 24th January. The division bench on 16th October, and then the case was carried to this court in the year 2019. And we are deciding it in 2024. The delay in this case is not unusual. We see several such cases when our final hearing board moves. Appeals of more than 2 decades are awaiting consideration. It is distressing, but certainly not beyond us. We must and we will find a solution to this problem. Seen in the light of the above judgment, it is now to be considered as to the measures of relief which can be provided to the appellant in the present case. In the light of the discussion, observation made herein above, a meritorious candidate who has been denied an admission in MBBS course illegally by the authorities for no fault, and who has approached the court in time so as to see that such meritorious candidate may not have to suffer for no fault of his stroker, we answer the reference as under. That in a case where a candidate stroke student has approached the court at the earliest and without any delay, and that the question is with respect to the admission in the medical colleges, all the efforts shall be made by the court concerned to dispose of the proceedings by giving priority and at the earliest, under exceptional circumstances, if the court finds that there is no fault attributable, attributable to the candidate, and the candidate has pursued his or her legal rights expeditiously without any delay, and there is a fault only on the part of the authorities, and or there is apparent breach of the rules and regulations as well as related principles in the process of grant of admission, which would violate the right of equality and equal treatment to the competing, one not be having competing candidates, and if the time schedule prescribed, that is 30th September, is over, to do the complete justice, the court under exceptional circumstances and in rarest of rare cases direct the admission in the same year by directing to increase the seats. However, it should not be more than 1 or 2 seats, and such admissions can be ordered within reasonable time, that is within 1 month from 30th September, that is cut-off date, and under no circumstances the court shall order any admission in the same year beyond 30th October. However, it is observed that such relief can be relief It can be done. In that case, the court is of the opinion that no relief of admission can be granted. You are writing relief again, relief can be granted to such a candidate in the very academic year, and wherever it finds that the action of the authorities has been arbitrary and in breach of the rules and regulations or the prospectus affecting the rights of the students, and that a candidate is found to be meritorious, and such candidate has approached the court at the earliest and without any delay, the court can mold, mold the relief and direct the admission to be granted to such candidate in the next academic year by issuing appropriate directions, by directing to increase in the number of seats as may be considered appropriate in the case, and in case of such an eventuality, BNT full abundantly, eventuality. And if it is found that the management, if it is found that the management was at fault and wrongly denied the admission to the meritorious candidate, in that case, the court may direct to reduce the number of seats in the management quota of that year, meaning thereby the students who were denied admission illegally to be accommodated. Here it is going to be in the next academic year on the basis of seats allotted in the management quota. Grant of the compensation could be an additional remedy, but not a substitute for the remedies. Therefore, in an appropriate case, the court may award the compensation to such a meritorious candidate who, for no fault of his or her, has to lose one full year and who could not be granted any relief of admission in the same academic year. The learned senior counsel appearing for the petitioner has submitted that the only dispute which was to be resolved and this board was with regard to the payment of due because of change in law which was held to be the actual cause of alternate code, UIL code, from imported code as specified by the auditor minus landed cost of domestic code. There was no other dispute which was to be resolved by this court. Learned counsel has submitted that it is now contended by the respondent that certain payments have been made by the respondents, which, according to the learned senior counsel, was towards regular payment on the basis of domestic linkage code and nothing else. Since the change in law ground of petitioner has been accepted by all authorities, that is RERC, APPL, and this court, and also confirmed by the dismissal of the review petition filed before this court, the question cannot now be reopened at this stage. It is thus submitted that since the actual landed cost of alternate code as was submitted by the petitioner has been duly certified by the auditors, which has not been disputed by the respondents, the payment as claimed ought to have been made, and since the same has not been paid, the respondents are liable for contempt. The further contention of the learned senior counsel for the petitioner is that the claim of the respondents that they had paid certain amount towards energy charges regularly month by month, which included certain amount of price of alternate code, which cannot be accepted as at that stage in the year 2013, the respondent had not accepted the claim of the petitioner with regard to the change in law and assertion now being made by the respondents that they had paid certain amount after partially accepting the change in law theory cannot be accepted as this issue had never been raised by the respondents in any proceedings earlier, as the respondents had in fact throughout contested that the petitioner is not entitled to the change in law benefit. The thrust of the content, thirst even. This is a thrust. There is a thrust of the contention is that the respondent number 2 on behalf of respondent number 1 had assured that the interest charged by respondent number 1 is as per the retail prime lending rate to be notified by RBI. As such, the interest which was indicated at 7% can be altered only if the RBI had altered the rate of interest and not otherwise. So, in the arguments, it is contained that the rate of interest would be as per the prime lending rate of interest. The respondent number 1, the same is contrary to the assurance that was held out to the appellant that such trade vendors agreed is only when the trade vendors is agreed by the reservant and not as per the interest of the interest by husband number one. The land senior counsel for the appellant in that regard has placed strong reliance on the email dated 5th October to contend that such assurance was made to appellant. The land senior counsel for the appellant has relied on two rulings wherein the issue considered was with regard to the exclusion clause in the insurance policy. Insurance is the insurance policy, which materially altered the nature of the contract. It was observed in this regard to an exclusion clause in an insurance policy which materially altered the terms and conditions of the contract. It was observed that the insurance contracts are standard form of contracts wherein the insurer, that is the dominant party, dictates its own terms and the consumer has big bargaining power. Be read and looking bargaining power, and as the contracts are one-sided, the concept of freedom of contract loses some significance in a contract of insurance. Such contracts demanded a very high degree of prudence, good faith, disclosure, and notice on the part of the insurer, being different facets of the doctrine of fairness, doctrine Dictation and doctrine of fairness. The bench consisting of two honorable judges was of the opinion that one cannot give a restrictive or narrow interpretation to the provisions relating to unfair trade practices as given under the Act. The court's finding against one of the parties for the existence of unfair trade practice and to be changed into an adequate relief in favor of the other, particularly in the light of Section 14 of the Act. Once the State Commission or the National Commission, as the case may be, come to the conclusion that the terms of a contract is unfair, particularly by adopting an unfair trade practice, the aggrieved party has to be extended the relief, which is further strengthened by Section 47 of the Act. It was also observed that under subsection 2 of Section 49 of the Act, the State Commission and the National Commission respectively may declare any terms of the contract being unfair to any consumer to be null and void, and there exists ample power to declare any terms of the contract as unfair if, in its opinion, its introduction by the company has certain element of unfairness. The dispute was regarding amenities promised by the real estate developer in their brochure, which were not delivered by law. It was noticed that once the commission arrived at the finding that the respondents therein were casual in their approach and had even resorted to unfair trade practice, it was its obligation to consider the appellant's grievance objectively and upon application of mind and thereafter gave its reasoned decision. Paragraph. If at all the appellant had not forfeited any right by registration of the sale deed, and if indeed the respondents were unable to provide any of the facilities as promised in the advertisement, it was the duty of the commission to set things right. In the said case, and in those circumstances, it was found by this court that fraud was committed by an officer and employee of the post office. It was held that the post office was an entity functions through its employees, and individuals are capable of being dishonest and committing acts of fraud or wrong themselves or in collusion with others. Such employees, when done during the course of employment, are binding on the post office at the instance of the person who is damnified, damnified by the fraud and harmful acts of the officers of the post office, and such acts within the course of employment will give right to the occurrence to legally proceed for injury, as this is their only remedy against the post office. Thus, post office, like a bank, can and is entitled to proceed against the officers. The loss caused to the fraud, but this would not absolve these officers them from their liability if the employee involved was active in the course of his employment and duties. From the perusal of the above noted cases, it would disclose that there are circumstances where certain aspects were contained in the agreement in question, but a contention was raised contrary to the same, and this court had rejected such contention. The learned senior counsel would, however, contend that though the parties may have agreed on certain aspects in the agreement, what is important is the intention of the parties and any correspondence exchanged between the parties as a prelude to the transaction before executing the agreements will be relevant to know the intention of the party. It is in that regard contended that the email dated 5th October 2005 was prior to the agreement dated 11th January 2006, and as such, the said intention should be gathered and given effect to, in order to persuade us to accept this contention. The learned senior counsel for the appellant has relied on the decision of this court, wherein it was contended that the petitioner therein had granted license to number 1 therein for the development and maintenance of terminal in terms of the agreement entered into between the parties in 2001. Contentions were raised that correspondence cannot be relied upon as the correspondence turned into a contract. It was held that while English jurisprudence is clear on the aspect of correspondence losing its significance once the contract comes into existence. Having perused the precedents on which reliance was placed, we are of the opinion that the same does not come to the aid of the appellant. In the instant case, at the outset, it is to be noted that the respondent number 1, being a company and as a corporate body, would be bound by its policies and procedures with regard to the lending and recovery. In that regard, the applicability of the rate of interest to be charged is also a matter of policy and cannot be a case unless the individual agreement entered into between the parties indicate otherwise. Paragraph. We have carefully perused the affidavit filed by the ministry before the tribunal. That said affidavit does not deal with ground J at all. It does not specify or set out reasons for concluding that in the public interest, the requirement of publication of prior notice was needed to be dispensed with. It is pertinent to note that before the issue of the second notification by which appendix, we have a new case appendix, was incorporated the procedure of inviting, procedure of inviting objections to the draft notification was followed and the objections were considered. There is no reason to dispense with this important requirement before publishing the individual notification. Article 21 guarantees the right to live in a pollution-free environment. The citizens have a fundamental duty to protect and improve the environment. Therefore, the participation of the citizens is very important and it is taken care of by allowing them to raise objections. Their participation cannot be prevented by casually exercising the power under sub-rule 4. In the grounds of challenge, ground E has been taken explicitly on this aspect. We have perused the counter affidavit filed by the ministry in these appeals. We find that the counter civil appeals and in the said affidavit, a contention was raised regarding the illegal invocation of power under sub-rule 4 of Rule 5 has not been cultivated. We are not going into the question of whether it was necessary for the central government to specify reasons in the impugned notification itself why it came to the conclusion that in the public interest, the requirement of public notice should be dispensed with. However, the reasons for the said conclusion ought to have been set out in the counter affidavit filed before the tribunal. The document recording the satisfaction of the competent authority about the existence of public interest and the nature of public interest ought to have been produced by the ministry. But no such document was produced. Only one conclusion can be drawn. The drastic decision to invoke sub-rule 4 of Rule 5 was made without any application of mine. Hence, the decision-making process has been vitiated. The imputed notification was issued 2 days after the nationwide lockdown was imposed due to COVID pandemic. At that time, the work of projects such as road, pipelines, etc. had come to a halt. So, there was no hurry to modify the notification. Apart from the fact that no reason have been assigned in the counter affidavit filed by the central government for coming to the conclusion that in the public interest, the requirement of prior publication of notice was required to be dispensed with. We fail to understand the undue haste shown by the central government in issuing the individual notification during the lockdown. Therefore, the inclusion of item 6 of the appendix will have to be held illegal. We have already given reasons for not dealing with the challenge to item 7 of the impugned notification. There is one more important ground for striking down item 6, but for item 6 in appendix to the impugned notification for extraction of ordinary earth raised for the project, prior consultation would have been required in terms of the notification. The very object of issuing the notification incorporating the mandatory requirement of obtaining clearance for project was that the damage to the environment must be minimized while implementing the projects. When an exception is sought to be carved out by incorporating appendix 9 to the requirement of obtaining clearance in the first notification, the exception must be specific. Item 6 grants exemption for extraction or borrowing of earth from the project, such as roads, pipelines, etc. There is no specification about the quantum of ordinary earth which can be extracted on the basis of the exemption. There is no specification of the area which can be used to extract ordinary earth. It is also not provided that only that quantity of ordinary earth which is required to implement the project is exempted. The process to be adopted for excavation has not been set out. Thus, item 6 is a case of completely unguided and blanket exemption, which is arbitrary and violative of Article 40 of the Constitution of India. There is no provision for setting up an authority which will decide whether a particular project is covered by item 6. As stated earlier, during the pendency of the appeals, an amendment was made to item 6 by the notification. Even the amended impugned notification does not elaborate on the concept of project. Elaborate and the only addition to item 6 is that the extraction shall be subject to compliance with SOP and environmental safeguards issued in this regard from time to time. The authority to issue the SOP and safeguard has not been specified. No provision has been made to enforce the SOP and environmental safeguards. No restriction is imposed on the quantum of ordinary earth which can be extracted for the project. Therefore, even the amended item 6 continues to suffer from the same vice of arbitrariness. The learned additional solicitor general relies on office memorandum. It provides that before carrying on activities mentioned in entry 6, the other project proponent must notify the State Pollution Control Board. The State Pollution Control Boards are required to monitor the compliance status of the safeguards. As entry 6 is arbitrary, hence on account of the violation of Article 14, item 6 in the impugned notification, as well as the amended impugned notification will have to be struck down. As noted earlier, the object of the act is to protect and improve the environment. Apart from the illegally committed by non-compliance with sub-rule 3 of rule 5 of the rules, the exemption granted without incorporating any safeguard, incorporating any third ordinary safeguard, is completely unguided and arbitrary. Grant of such blanket exemption defeats the very purpose. In paragraph A of the impure order, which we have quoted earlier, I told which we have, which we have quoted earlier, the tribunal observed that the exemption needed to be made by appropriate safeguard such as the process of excavation. Therefore, in paragraph 9, a direction was issued to the ministry to revisit the impure notification in the light of the observations made in paragraph 8 within 3 months provided by the tribunal to do so. No steps shall be taken to revisit item 6 of the impure notification. The ministry has filed an additional affidavit dated 18 July 23 and Reliance has been placed on the guideline for mining as well as item 6 is concerned. In the counter affidavit, Reliance was placed in the order dated 8 August 22, purportedly issued in terms of the direction issued in paragraph 9 of the impure judgment. It records that item 6 shall be subject to the SOP attached to the civil appeal. We have perused the SOP. We find that the SOP creates no regulatory machinery to ensure the implementation of the terms of the SOP. The SOP does not refer to item 6 at all. It merely refers to the activities relating to the identification to borrow area to obtain earth or soil. It does not refer to extracting ordinary earth for the projects such as roads, pipeline, etc. Therefore, the said SOP can hardly be said to be in terms of what the tribunal ordered the central government should do in terms of paragraphs 8, 9, and 30. We are not entertaining a challenge to item 7 of impure notification, as none of the respondents have challenged the impure notification. They will have implement the directions imbued in the third segment. Thus, notwithstanding the specific directions issued in paragraph 8, read with paragraph 9 of the impure judgment, no safeguards have been provided, such as laying down process, the mode and the manner of excavation and quantum. How they move first? No. No, how they move here. The appellants are being prosecuted for offences punishable under section 419 and 420 of the IPC and section 66, relative section 43 of the Information Technology Act. The charge sheet has been filed and the trial has proceeded. By the impure order, the High Court rejected the appellant's application for regular bail. Appellant's application. During the course of hearing of an earlier date, we were informed that the trial court recorded the examination chief of 12 prosecution witnesses, one after the other, on different dates without recording their cross-examination. Therefore, considering the peculiar procedure followed by the learned trial judge, we requested the learned trial judge to submit a report. Paragraph. We have perused the report dated 11 March 2024 of the trial court, which records that by an order dated 27 June 2023, a direction was issued by the High Court to complete the trial preferably within a period of 4 months. Therefore, the charge was framed on 30th May 23 and from 25th July 23 to 7th February 24, evidence of 12 prosecution witnesses was recorded. The report records that the evidence of the prosecution witnesses was recorded in the presence of the appellants, but their advocate was not present as they had not engaged any advocate. Paragraph. In our view, the trial court ought not to have recorded the evidence in this fashion. Before recording the examination in chief of the first prosecution witness, after finding that the appellants accused had not engaged any advocate, the trial court ought to have provided a legal aid advocate to the appellant accused so that the evidence of the prosecution witnesses could have been recorded in the presence of the advocate representing the appellant accused. The order sheet enclosed with the report does not record that the appellants declined to accept the services of a legal aid lawyer. Paragraph. When the examination in chief of a material prosecution witness is being recorded, the presence of the advocate or the accused is required. He has a right to object to a leading or irrelevant question being asked to the witness. If the trial is conducted in such a manner, an argument of prejudice will be available to the accused. This is a warrant case. In a warrant case, in view of the provisions of subsection 3 of section 242 of the CRPC, the learned magistrate, by recording reasons, can permit cross-examination of a witness to be postponed till a particular witness or witnesses are examined. However, in the present case, no such order was passed by the learned magistrate. The normal rule is that witnesses shall be examined in the order laid down in section 138 of the Act. The learned judge seems to have adopted this method only because the High Court had fixed a time-bound schedule for the disposal of the case. He could always sought an extension from the High Court. Therefore, recording only the examination in chief of 12 prosecution witnesses without recording cross-examination is contrary to the law. Paragraph. Considering the facts of the case and the nature of the offense alleged against the appellants, and also considering the fact that the appellants have been in custody since 8 January 23, we find that a case is made out for enlarging the appellants on bail pending the trial subject to stringent terms and conditions, including the condition of deposit of the passport of the appellant with the trial court. To avoid any argument of prejudice, we direct the magistrate to conduct a fresh trial by again examining the prosecution witnesses who have been already examined. The learned counsel appearing for the appellant states that a direction may be issued to the court. Hence, we allow the civil appeals by passing the following order. We direct that the appellant shall be produced before the trial court on 27 March 24 at 10:30 a.m. On that day, the trial court will appoint a legal aid advocate to expose, process these expose the cause of the offense. We direct the trial court to enlarge the offense on bail on appropriate stringent terms and conditions till the conclusion of the trial after giving an opportunity of being heard to the learned prosecutor on the terms and conditions of the bail. The conditions of bail shall include the condition of the appellant surrendering their passport before the trial court. We direct the trial court to hold a fresh trial by examining the prosecution witnesses also. You tired of writing? Did you go to court something? I have taken to take 4 hours continuous dictation at the 60 word per minute. The chief justice pepper 4 hours continuous without the start way. That's why I gave you long dictation. Some outlines I see that, but after 3-4 months, I am going to give my dictation and I will tell you to translate. That is going to happen after my training is over. But you follow my. You find difficulty taking down dictation. Well, because I am searching your outlines. Because clear to you, no problem. But my guidance you may not be able to take out. In my group, I have created a group nearly 200-300 students. You are not there. You are. Still, lot of members are thought that they are finding very easy for the exam conductor yesterday. So, all say very good, very good. I don't know, all will pass without. But they are continuously practicing. You are in that group. Anyone else in the group? No. So I am going to give the same dictation which I had given previously. You follow that same. Follow that. So I gave nearly 5 minutes dictation of more than 600-700 passage. But you have to know some time for me every day. I will send you either way some outlines or some passages you must follow a dictation. Okay. Okay. It seems to us that the above mentioned view of the effects of the event control legislation in section 106 of the Act implies a virtual repeal of the latter by the former. But neither the Delhi Rent Control Act nor the analogous, yet communal case of analogous rent control legislation repeals the provisions of section 106 of the Act. Repeal by implication is not favored by court. It's only if the rent control legislation is shown with section 106 of the Transfer of Property Act that the latter could be said to have been repealed, repealed, or overridden by the former to the extent of the inconsistency and discount society and other. A similar problem was considered by the Supreme Court. Over and above the general law under which the government could bring a suit for the recovery of its immobile property from an unauthorized occupier, which enabled the government and its officers acting under the said act to summarily evict unauthorized occupiers of public property after a summary inquiry under the act and without having to file a suit in a court of law. The question was whether the new act was supplementary remedy available to the government in addition to the primary one under the general law, or whether the new remedy completely substituted the old one so that the only new remedy was available and the old was not available to the government at all. The minority of the Supreme Court held that the new act gave only an additional remedy to the government, and there was nothing in the new act to warrant the conclusion that it took away the right of suit from the government. You can read it. Now, you read it.
And all of the control legislation in section 106 of the
And the implies
letter by farmers. Very control act, not the
analogous and counter rent control legislation
of section 106 and
some omission of the repeat by indication
is not necessary only
mistakes. Your it's not indicated. But internet is it's not available for it is online data. Okay. Could be family forward data by foreigners yet for their environment first month. Foreigners yet for their environment. Foreigners first month. Okay. Problem. Can you do it? I don't know that it's so and its offices under the under London that somebody surplus and way upward somebody trading another or somebody required under the act. Find F downward, following the forward, finding F downward. This is the advantage. I noticed that. You can read it. Read it. Movements are upward, yeah, diagonally and primary. Please stop and I give the and you read. Take out. It is true that such a clause was not present in the Bombay and Madhya Pradesh rent control legislation considered by the Supreme Court. In our view, however, the presence or absence of non-obstante clause is of little consequence. In either case, the question for decision is whether the provisions of section 106 of the Transfer of Property Act are repealed, superseded, or overridden by the rent control legislation. It is only if the rent control legislation cannot stand side by side with section 106 of the Act that such an implied repeal can come about. Even the presence of non-obstante clause does not necessarily mean that the provisions of section 106 of the Act are repealed thereby. From the point of view of the landlords, it is generally argued that the landlords have been given a new right by the rent control legislation to evict tenants on the ground specified therein. In our view, this is a wrong way of looking at the legislation. Its effect is to place additional restriction on the right of the landlord to evict the tenant even after the termination of the contractual tenancy. The thrust of the non-obstante clause in section 14 is against the landlord. What it says is, even if the landlord is entitled to evict the tenant under the general law after a notice to quit, still the rent control legislation will continue to protect the possession of the tenant unless some further defaults or misconduct by the tenant or the need of the landlord specified therein are proved by the landlord to the satisfaction of the controller. It is not possible, therefore, to distinguish the above mentioned decisions of the Supreme Court, which clearly lay down that the determination of contractual tenancy is essential before an application can be filed by a landlord against a tenant according to the rent control legislation. Full stop. Yes.
It is that so it was normal building in the and control legislation.
Substandard. These are the CNP. Full of them. Non-substandard clause.
Legislation considered by the Supreme Court in our view, however, the presence or absence of non-opposed
CNP.
or little consequence in either case. The question for decision is whether the provisions of section 106 of the Transfer of the Property Act and repeal
Field.
the substandard
Super surplus per surplus we have. Super serial.
At the rent control legislation, it is already if the rent control.
It's already. These surplus not. I know it.
If the rent control legislation again stand side by side.
They are not.
Side by side in
This section 106.
106 of the act, that such a implied
Implied, empty. Empty. Implied. Repeat. Raise the upward.
If can income above even the presence of no extended
Clause.
clause does not necessarily mean that the provisions of section 106 of the act are repeated thereby.
You can read it.
The landlord means under argument that landlord.
Generally, generally is put wide there so that you will not mistake.
Generally, argued that the landlord have been given a new right by the rent control legislation to rent. In a way, tenants on the ground specified their nor view this is a wrong way on looking at the legislation. Its effect is to place the additional restriction on the right of the landlord to evict the tenant even after the termination of the contractual tenancy. The first of the non-standard clause section 114 is against the landlord, but say even after the landlord even if the landlord is entitled to evict the tenant under the general law after a notice to quit, still the rent control legislation will continue to protect the position of the tenant unless some further defaults or misconduct by the tenants or the need of the landlord specified therein are proved by the landlord to the satisfaction of the country. It is not possible control. It is not possible therefore to distinguish the abomination decision of the Supreme Court, which clearly laid down that the determination of contractual tenancy essential before application can be filed by landlord against the tenant according to the rent control legislation.
We are supported in this view by the full bench decision of the Punjab and Haryana High Court, adopting the second view after overruling that decision, in which they form the basis of the first view. Our view as to the effect of non-standard clause is further supported by the decision of the full bench. Notwithstanding anything in any other law for the time being in force, no suit or proceeding for the recovery of possession of any premises on any ground mentioned in subsection 1, except the ground mentioned in clauses J and K of that subsection shall be filed by the landlord unless he has given to the tenant 1 month's notice expiring with a month of the tenancy paragraph. At first stage, it would appear that the above provision completely superseded section 106 of the Transfer of Property Act. Nevertheless, the learned judges pointed out that notice under section 13 of the Act required a notice for the determination of the tenancy. The two notices were different and therefore section 13(6) did not supersede or repeal the provisions of section 106 of the Act. In section 14 of the Act, there is no such provision for a month's notice expiring with the month's notice with the month of tenancy. It cannot be argued, therefore, that section 14 can at all have the effect of repeal. Waiver is a right. Such a right may be based on either on a contract or a statute. The terms of the contract are subject purely to the agreement between the parties. Courts are therefore inclined to uphold reasonable arrangements for the relaxation of terms between the parties. The waiver of a contractual right is therefore caused by contract. Rights arising out of statutes may be two kinds, namely those which are purely for the benefit of a person or a class of persons, and those which represent some public policy or other public considerations with resultant benefit to the person or a class of persons. Paragraph. The tenant has no inherent right that his tenancy should be terminated by a notice. Such a right may be given to him by his contract with the landlord. In the absence of a contract, section 106 of the Act requires a tenancy should be terminated by a notice. This provision is for the benefit of both the landlord and the tenant. As pointed out in the said case, section 106 itself opened with the words, in the absence of a contract or local law or usage to the contrary. These words show that the requirement of notice under section 106 is not rigid. Parties may enter into contract to the contrary at the time of entering into a lease. Since the lease itself is based on contract, the parties may agree to vary its terms by a subsequent contract. One of the parties may even agree to abandon their right given to it by section 106 in the absence of a contract to the contrary. If the requirement of notice can thus be waived by an agreement between the parties, it would be reasonable to think that it could also be waived by such conduct as would be the evidence of the intention of the parties. Section 106 itself contemplates that the termination of the lease may come about otherwise than by the notice contemplated therein. Thus, viewed, the requirement of notice under section 106 is essential for the benefit of the parties. The requirement is not mandatory as section 106 itself shows that the tenancy may be terminated in some other way. This is why this statutory right of the tenant must be held to be capable of being waived by the conduct of the tenant is not insisting upon the notice that has been acted on by the landlord, and the landlord would be changing his position, relying upon the conduct of the tenant would be stopped. We have stopped. On the contrary, certain statutory provisions give a right or an immunity, immunity or protection to certain persons as a matter of public policy. Such statutory provisions cannot be waived. That is why, for instance, prohibition against the subletting of the premises, subletting of the premises by a tenant was held incapable of being waived by the landlord. Similarly, when the court does not have jurisdiction to deal with a matter, parties cannot give it such jurisdiction, and therefore the objection to a lack of inherent jurisdiction cannot be waived as held in the said case. Paragraph. For the same reason, a tenant cannot agree to waive statutory protection given to him by the provisions of section 14 of the Act. It is clear, however, that the requirement to notice under section 106 is not based on any mandatory provisions based on a public policy. They can therefore be waived. Waiver of terms and conditions implies that the person waiving his right is aware of the right. If he did not know of the right at all, of course, there could be no waiver. The right given to the tenant under section 106 of the Act against the provisions of section 14 of the Act was a matter of common knowledge, especially because it was a statutory right. It would appear from the course of litigation in this court that the tenants were not generally raising the plea of want of notice under section 106 of the Act in defense in a petition for eviction by the landlord under section 14 of the Act following the Punjab and Haryana High Court judges' view expressed in the said judgment. They started raising these pleas mostly after the decisions of the Supreme Court. As pointed out by us, however, the Supreme Court has been expressing the view that the provisions of section 106 of the Act were not superseded by the provisions of the various acts from their decisions. We have also pointed out that the mere fact that clause 100, I mistake. It cannot be said, therefore, that the tenant became aware of the protection given to him by section 106 of the Transfer of Property Act, namely section 14 of the Rent Control Act, for the first time after the decision in the said case by the Supreme Court. As a rule of statutory right must be considered to become known when the statute is enacted, it would not be correct to argue that such a right becomes known only after the interpretation of the statute by the court. For the interpretation is not supposed to make new law, but only to point out the law which already existed. It is only if a statute is held unconstitutional for the first time by a judicial decision that a right based on such constitutionality would be said to become known for the first time by such a judicial decision. This view finds support in the relevant provisions of the CPC. Under Order 6, Rule 4, a party which relies on a particular circumstance such as misrepresentation, willful default, etc., and in all other cases where particulars will be necessary beyond such are exemplified in the form of appendix. The particulars shall be stated in the beginning. The compliance with the provisions of section 106 of the Act is extremely important in the proceeding between the landlord and tenant. It is therefore absolutely necessary that the party which relies upon compliance or non-compliance must give the particulars in the beginning. Under Order 6, Rule 6, the party interested in stating anything about the performance or otherwise of a condition such must make a distinct pleading about it. Ordinarily, a landlord applying for an eviction of a tenant must plead that the tenancy has been terminated. If the tenant does not make the plea that the suit or the application is untenable due to the termination of the tenancy, then he would be either deemed to have admitted the allegation of the landlord or to have waived the benefit of protection of section 106 of the Act. If, however, landlord fails to plead the termination of the tenancy, then the situation arises whether his petition for eviction of the tenant would be liable to be rejected for want of a course of action. In our view, the answer to this question should be in the negative. For in addition to the termination of the tenancy, some other acts such as wrongful acts of the tenant also constitute a cause of action for eviction. The mere omission to mention the termination of tenancy would not amount to a non-disclosure of the whole cause of action. For that, the cause of action would still be disclosed. It is even arguable that the necessity to plead the termination of a tenancy is not so much a matter of setting out the cause of action as one of making a relevant and perhaps necessary pleading paragraph. The question whether the failure of the tenant taking the plea of non-compliance with section 106 of the Act and the said plea and whether the landlord is thereby exempted from the necessity to comply with section 106 of the Act can be answered only after the nature of the compliance with section 106 of the Act is understood. We have stated above that such a compliance is not a jurisdiction condition, nor does the jurisdiction of a court or the rent control depend on the satisfaction of this condition. The complaints must, however, be pleaded by the landlord. But the failure to make such a pleading would not ordinarily amount to non-disclosure of the cause of action. It is for these reasons that we are inclined to the view that the failure of the tenants to raise the objection regarding the non-compliance with section 106 of the Act at an early stage of the litigation would amount to a waiver of plea, tax, and circumstances of each case when the conduct of the tenant would amount to such a waiver. The greater the delay on the part of the tenant in facing such a plea, the greater the probability of his contract amounting to waiver. This court has taken the view that the failure of the tenant to raise such a plea before the controller would amount to a waiver of the tenant to raise such a plea, and therefore the plea cannot be raised for the first time in the appeal, much less in the second appeal paragraph. If the minority of two learned judges against the dissent of one of the learned judges took the view that the tenancy must be determined before eviction for eviction under the Act is filed by the landlord. This view is in accordance with the finding given by us on question number 1. We also need not agree with the minority view that it was for the landlord to mention in his claim the fact of determination of the contractual tenancy as one of the facts consisting the course of action which is required. Full stop. Their lordships, however, further observe that if the plaintiff landlord fails to make such a pleading, then the tenant can take the plea of non-compliance with section 106 of the Act for the first time on second appeal. We find ourselves unable to agree with this observation of their lordships for the reasons already stated above, namely the plea regarding the termination of the contractual tenancy does not constitute the whole of the course of action for a petition for eviction, with the result that facts consisting the rest of the course of action that the non-compliance with sections 106 of the Act does not go to the jurisdiction of the court. It is to be further noticed that the statutory requirement of notice under section 106 of the Act is for the benefit of the parties to the contract of the tenancy. There is no public policy behind it. That is why the requirement can be waived by the parties. With this requirement, the necessity of notice under section 80 may be said to be based on public policy, inasmuch as the government has to be given time to consider the claims made against it, so that the government may admit or settle unnecessary litigation, and the waste of public time and money should be avoided. In the said case, it was held competent to the Secretary of the State to waive notice under section 80 CPC, and he has held to have been stopped by his conduct from pleading the want of notice at a later stage of the trial. Thus, where the Secretary of the State took objection to the sufficiency of the notice in his written statement, but raised no issue on the point when issues were settled and took no objection during the trial, the court held that another defendant was not competent to raise this issue at later stage, as the Secretary of the State had waived the notice under section 13 of the Act, which can be waived, and it was waived in the present case. In the present case, the landlord specifically stated in his petition for eviction under section 14 in column 18 as follows: notice not required but notice dated 9th September 1963 was given, copy attached. The notice was of a fortnight, terminating the tenancy at the end of the month. The tenant did not object to the maintainability of the petition on the ground that the tenancy had not been terminated by the notice to quit. The reason was very obvious. The landlord had actually terminated the tenancy and produced a copy of the notice and the reply received from the tenant. The tenant formally denied them merely to put the landlord to their proof. The view current among the Delhi lawyers in those days was that the Delhi Act was a self-contained code and that it was not necessary that tenancy should be terminated before the petition could be filed. This was the landlord expressly aware that no notice was necessary. The tenant was also obviously under the same impression and therefore did not object to the maintainability of the petition on the ground of non-compliance with section 106 of the Act or with the principle underlying it. The controller was also apparently of the same view. Therefore, the question of compliance with section 106 of the Act or the principle underlying it was neither raised by the parties nor decided by the controller. It was left and unnecessary for a decision by the parties as well as by the controller. Yeah, coming from the discussion of one of your. Fine, we are not attached to any hearing board. You go to any hearing board, then you will get, but now, I don't tell you, previously the judges used to receive one of your, I think, how much these after. So now you will get my discussion through WhatsApp, but training will continue for the next day, no? In addition to that, I send daily meeting, but you say it that you want sometimes another one day. I will send that. I think I'm ready to add it in that. Now, cinema Cinema, I think is that